Absolutely.
Okay,
Well, good morning, everybody. I'm Representative Tom Demmer from Dixon. I do want to update you on a couple of things that have taken place since the Special Investigative Committee last met. As you recall, during that committee, we as three members of the investigative committee thought that it was important during the course of an investigation to not simply hear from witnesses who were voluntarily willing to come before us and testify, but also importantly to hear from people who we believe have relevant and useful information that would be needed by investigators in order to make a qualified decision about the charge that's before us. And so we had a debate during the committee about the issuance of subpoenas. Now, issuing subpoenas is a power that is held by any committee of the House and is especially useful power that is delegated to investigative committees, given the seriousness of their charge and the nature of investigations. Chairman Welch at the committee ruled a motion to issue those subpoenas to be out of order and cited multiple times that he had not seen the subpoenas that we requested to be issued. So in order to clear up that step, we have sent to Chairman Welch drafts of each subpoena that we intend to issue. Now those subpoenas would be issued to the members or the individuals who are identified by House Republicans in witness letters from the first meeting, as well as Mr. Ochoa, Mr. Olivo, and Mr. Nice, whose names were brought up during testimony by ComEd. So we've issued those, sent those letters to Chairman Welch, and we believe that it's important that the committee exercise its subpoena power to bring in those individuals to give us the same kind of valuable insight and information that Commonwealth Edison was able to provide at the last meeting. The second item is that at the conclusion of questioning of Mr. Goldner from Commonwealth Edison, he indicated that Commonwealth Edison was in possession of additional communications and documents related to the deferred prosecution agreement from Speaker Madigan or Speaker Madigan's associates. He said he was in possession of those. They didn't have them at the committee, but they would be willing to provide those. And so today I have drafted a letter to Mr. Glockner asking for him to submit those documents to the committee for our consideration. And we'll be issuing that letter later this afternoon. So I do think it's important that the committee, as we've stressed many times, this is an investigation. It's important that we have comprehensive information and that we bring forward individuals who have that information to testify before us. We've received multiple assurances and green lights from the United States Attorney's Office to provide cover that the committee needs to ensure that our questioning and our calling of these witnesses will not jeopardize the ongoing investigation from the federal government. We think it's important that we hear from Speaker Madigan. I asked directly of the U.S. Attorney if they had any objection to us calling Speaker Madigan as a witness, and they had no objection to that. So I think it's important that we bring those individuals and documents forward so our committee can make an informed decision. With that, I'll hand it off to Representative Mazzochi.
Thank you, everyone. I apologize. No, I really am off the mute button. So thank you very much. Good morning. I'm Deanne Mazzochi, State Representative for Illinois' 47th House District, and I am an Elmhurst resident. I'd like to talk a little bit about the how and the why we actually need to have subpoenas going forward in this situation. Now, I believe every person who's listed in the deferred prosecution agreement should be coming before this committee to state what they know and attest to the truth. We have asked the major players to come forward voluntarily: ComEd, McLean, Doherty, Hooker, Promaggiore, Marquez, Zaleski Sr., and of course, Illinois House Speaker Mike Madigan. ComEd humbly did come forward. Mr. Glockner was certainly a good and credible witness on ComEd's behalf, but as he acknowledged, he was not himself at ComEd when some of this most egregious behavior occurred. Now, we know that there's now a disparity between what the speaker is saying, where he professes to be little more than a benign bystander, and what the deferred prosecution agreement says and what ComEd has now confessed to before the committee. Let me give you an example of this. As we confirmed at our most recent hearing, the ComEd deferred prosecution agreement admits that Mike Madigan sought the appointment of one of his associates, Juan Ochoa, to the ComEd Board of Directors. ComEd resisted doing this. As our hearing confirmed, ComEd asked if they could give Mr. Ochoa the same amount of money, $78,000, but not the board seat. Their internal board members just didn't want to give him that seat. The deferred prosecution agreement admits that Mike McLean told Ann Promaggiore in no uncertain terms that this would not satisfy Speaker Madigan. They wanted a board seat for Mr. Ochoa. Now, the speaker said in an undated letter that I received on Friday, September 25th, 2020, that I believe went to all the members of the committee, that when it came to ComEd and what he called individuals, this was his words, purportedly recommended, close quote, for hire. He said, Speaker Madigan did, quote, that attempt was never made known to me. If it had been, it would have been profoundly unwelcome. That's what the speaker said in his letter. Not under oath, of course, but he did say didn't come from him. Yet ComEd testified before our committee that they received a letter from the speaker's own office manager. ComEd testified to our committee that the speaker's office manager forwarded Mr. Ochoa's resume to them. And ComEd also testified that this email indicated that the speaker wanted ComEd to have that resume. So right now, our committee is looking at a profound disparity between what the speaker has said and what ComEd has testified to under oath. And there's many other things that we need to confirm or deny that relate to Speaker Madigan and his knowledge, his authority, or lack thereof, and it needs to be done in person and under oath. And we certainly, as I've said before, we would love to hear his point of view, because if he really does think that there is something that's wrong in the deferred prosecution agreement with ComEd, he should come forward, show us his evidence, and we can then, forward this information on to see if any of his denials are plausible. Now, when it comes to the subpoena power, let's talk about that for a bit. Our Illinois Constitution, unlike the federal Constitution, and this is in Illinois Constitution, Article 4, Section 7, subsection C. It specifically states, quote, either House or any committee thereof, as provided by law, may compel by subpoena the attendance and testimony of witnesses and the production of books, records, and papers. By law, in Illinois statute 25 ILCS 5/4, the presiding officer of each house and the chairman or any member of any committee appointed by either house or of a joint committee appointed by the two houses of the General Assembly may administer oaths and affirmations to witnesses called before such house or committee for the purpose of giving evidence touching any matter or thing which may be under the consideration or investigation of such house or committee. 25 ILCS 5/6 says, quote, any person may be compelled by subpoena to appear and give testimony as a witness and produce papers and documents before either house or a committee thereof. And then it goes on further from there. And the statute further says, further, nothing in this act shall be construed to exempt any witness from prosecution and punishment for perjury committed by him in testifying as foresaid. So it was very surprising to me when we came before this committee. We knew that in connection with the Derek Smith investigation, while the members there sought voluntary testimony and appearances from individuals, and they sent letters to that effect, those same letters also warned, if you do not appear voluntarily, then that could lead to this committee exercising its subpoena power. So it's not unusual that if a witness refuses to appear voluntarily, that the subpoena power is the next step in the process for having that witness appear. Now, when so many of these witnesses said they would not appear voluntarily, then the next step in the process is to issue the subpoena. I was actually very surprised that Chairman Welch did not have drafts ready to go for our consideration before our next meeting. So the chairman talked about his surprise, but he also surprised me with his apparent willingness to preemptively surrender the investigative powers of this committee, which are contemplated in the Illinois Constitution and by statute. All of these individuals, when responding to our request, showed they're represented by able counsel. If those attorneys wish to raise objections to a subpoena on either the procedure or the merits, I will doubt they will be shy. The chairman seemed intent on raising obstacles to proceeding with subpoenas. He did this without consultation or consent for our side, and we certainly would not consent to that, because why should this committee give up any tool or opportunity to get to the truth? Now, before quarantining himself, the governor came out in favor of saying he believes the speaker should appear. I would like to invite not just the members of our committee, but each of my colleagues in the General Assembly to join the governor in urging the speaker to appear. Michael J. Madigan must come before this committee to testify under oath. Now I believe we'll turn it over to Grant Wehrli.
Thank you, Representative Mazzochi. My name is Grant Wehrli, representing Naperville and Warrenville. Speaker Michael J. Madigan needs to step forward and testify. He can choose to do so voluntarily, or we believe subpoenas should be issued as outlined by Representative Mazzochi. Just yesterday, Governor J.B. Pritzker once again reiterated his calls, quoting, "The speaker has a lot to answer for," and that he strongly urges Speaker Michael J. Madigan to step forward and testify. In the letter dated, or actually not dated from Speaker Madigan, but received on September 25th, he states, quote, "I have done nothing wrong," end quote. Speaker Madigan, if that is correct, then what is the harm in stepping forward and removing this cloud of darkness over our state capitol? If you truly have nothing to hide, come forward and clear this all up. We heard through the testimony of Commonwealth Edison in the deferred prosecution agreement, statements of facts. These are admitted facts. These are not allegations. These are not charges. These are admitted facts. In that document, the speaker is mentioned dozens and dozens of times. He needs to step forward voluntarily or via subpoena and clear his name. We also heard on Thursday in the courtroom at the Federal Dirksen building, the first guilty plea in this ongoing massive federal investigation. Fidel Marquez pled guilty to conspiracy to commit bribery. In that guilty plea, public official A, Speaker Michael J. Madigan, is mentioned 31 times. Once again, raising even more questions that we all have. If he's done nothing wrong, the speaker needs to come forward and answer these questions. These are questions that the governor has, that we all have, that Democrats that asked for his resignation have, that Democrats that have said, if true, he must step aside. These are questions that ratepayers of Commonwealth Edison have. They are the ones that in the end will be on the hook for financial damages here. We all need answers to these questions. Subpoena, if that's the way we have to go, needs to get done. Either voluntarily or via subpoena, Michael J. Madigan and others need to step forward and do what is right for the residents of the state of Illinois and answer the questions that we all have.